I call this meeting to order. Welcome to meeting number 64 of the House of Commons Standing Committee on Public Safety and National Security. We will start by acknowledging that we are meeting on the traditional unceded territory of the Algonquin people. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25, 2021. Members are attending in person, in the room, and remotely using the Zoom application. Pursuant to the order of reference of Thursday, June 23, 2022, the committee resumes consideration of Bill C-21, an act to amend certain acts and to make certain consequential amendments, firearms. The committee resumes the debate on Amendment G3-2, and I will now welcome the officials who are with us once again today. From the Department of Justice, we have Marianne Breese, Counsel, Criminal Law Policy Section. Paula Clarke, Counsel, Criminal Law Policy Section. Phaedra Glushek, Counsel, Criminal Law Policy Section. From the Department of Public Safety and Emergency Preparedness, Rachel Mainville-Dale, Acting Director, General Firearms Policy. From the Royal Canadian Mounted Police, Mr. Rob Daly, Director, Strategic Policy, Canadian Firearms Program. Ms. Kellie, Paquette, Director General, Canadian Firearms Program. Thank you for joining us again. We look forward to your valuable contributions as we proceed. So we will continue the speaking list from our last meeting. Mr. Mott's had the floor, however, he's not present, so we will continue with Mr. Moff, followed by Madame Michaud, followed by Mr. Julian. Mr. Moff, please, if you will.
Thank you, Chair. We had an extremely frustrating last meeting in that we were 2.5 hours discussing the amendment that I've put forward and numerous other things which are not even part of this bill. So I am hopeful that today we'll be able to move a little bit more efficiently because there are really important things in this bill beyond the amendment, and colleagues know that when it comes to police services and access to ghost guns, whether it's instances of gender-based violence and prohibition orders, and also increasing the sentences for firearms offenses that are listed to organized crime. So, you know, we have 146-ish, 150 amendments in front of us here today. I recognize that a number of them are, hopefully we can go through fairly quickly, but I'm hoping we can be efficient and get through this at a relatively quick pace. So I'll leave it there right now, Chair, until we hear from some of our colleagues and see how the meeting's going to go today.
Thank you, Mr. Moff. We go now to Madame Michaud. Allez-y, s'il vous plaît.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. I'd like to thank, of course, our witnesses for being here today. It's been a long haul the last few weeks, and we have to understand that no definition will be available, and at the Blanc we understand the difficulty of creating a definition that will please everyone. Regardless of what we're going to come up with, they're going to have 5 different interpretations of how it should be interpreted. The designations might be all different. And nonetheless, as I said at the last meeting, I'd like to recognize the courage of the government in withdrawing their last amendment and undertaken consultation with various groups, which should have occurred since the beginning. We've also been consulting on our side, and we've had proposals of definitions which are quite different with everybody that we consulted. It's not an easy task. but I believe we can try to improve the definition nonetheless. I'd also like to underline that in the French version, a hunting gun or fusil de chasse is a very common expression, and it's not bad to use it because a lot of hunters will recognize it. So it was simplification, common language, if you will, and it will assist in communicating with the public. The definition is acceptable for that particular firearm. We might be able to improve it further, depending on the comments and advice that we've received, and of course with the assistance of the officials that are here today. I'm sure a lot of people are watching us today, people who are interested in hunting, civil society, the indigenous population. So we have to make this the best law possible so that we can try to satisfy as many people as possible, all the while maintaining public safety. Now, there is point 1.2 with the detachable multi-cartridge charger, magazine, I should say. A weapon would become immediately illegal if somewhere in Canada someone decides to sell a high-capacity magazine for these weapons. Now, the intention of the manufacturer is quite unknown. There's usually a magazine that accompanies every weapon, and it's usually not a high-capacity magazine. However, they could, in fact, have one with 5 cartridges in Canada, magazine capacity, and another one for other markets, 40 cartridges or bullets. I'd like to know how we might determine if the manufacturer's intention has not been initially to provide a 30 charge magazine with these assault type weapons. Or I'm not sure if it's out of the box that way, but I was wondering how we might deal with that.
So every firearm in their specifications, designs, they will identify what cartridge magazine is intended for that firearm. So in the ones that, and they're all over the map, like some of them can come out with 2, 4, 10, 20. Others are originally designed just for 2 and 4. It really depends on the manufacturer or the designer of a firearm and the firearm itself, of what type of cartridge magazine it will be designed for.
Je vous remercie et
Thank you for that. Now, when we're talking about classification or categories, there's no regulatory. If a weapon has already been classified as unrestricted, what factor would you insist on? If there's no statutory or regulatory changes, are there other factors involved in the classification?
So this definition would be prospective, so it would be for the future. But given the classifications today, it does not take a cartridge magazine into consideration for classifying a firearm as non-restricted, restricted, or prohibited.
je vous remercie pour
Thank you. And for an example, perhaps in Canada, if we have a charger of 4 cartridges, in the United States is being sold with a 20 cartridge magazine, is there a mechanism, a process by which we could review the classification in the context that there has been no regulatory or statutory changes?
If I understand the question correctly, if I may, I'll ask it back just to make sure I'm understanding it correctly. So is there a mechanism for, and this I guess would be outside of a design, so a firearm is designed for a 4, but then later on it's identified to also, or a new cartridge is developed that also fits that firearm, that is a 20 that could be used in the United States? And is there a mechanism for us to regulate? I think that's what I'm hearing.
De revoir la classification de l'arme.
To review the classification, because now it's
Original design, right now, the way that it's written, it wouldn't be considered.
Je vous remercie. Le deuxième aspect.
the second issue I'd like to deal with. It's for a weapon which is designed with a magazine of 6 or more cartridges. And here's what we said about the mass killings in Newfoundland.
All semi-automatic handgun and all semi-automatic rifles and shotguns that discharge center-fire ammunition and that are designed to accept detachable magazines with capacities of more than 5 rounds. La définition du gouvernement.
The government definition is very close to that in a way, but there is a few details. They don't talk about the possibility of using a magazine with higher capacity, but the design of it on the original magazine. The definition of a semi-automatic weapon could be the criteria which decides what it is, whether it is prohibited, restricted, or unclassified by design. Some weapons, of course, no matter what the size of the magazine would be considered either prohibited or restricted. Whether it was 5 bullets, and the next month it comes out in a 30 cartridge magazine capacity. Nonetheless, the weapon was initially designed and classified as a weapon with a 5 cartridge magazine. And as Ms. Paquette mentioned, we have yet to classify all future weapons as we don't know what they are. Mrs. Benshaw was asking at the last meeting, if I understood correctly, they're talking about a prospective definition, so it doesn't yet exist. Now, if we were to use the Commission's definition of a high-capacity magazine, could mean an retroactive prohibition. But the RCMP is not going to reevaluate a classification of any weapons. There's been no changes so far and no retroactivity on these weapons. If we come back to the Commission's recommendation, a high-capacity magazine was used rather than what was provided by the original manufacturer. How are we going to prohibit the entry of these types of weapons that can be so readily adaptable with detachable magazines unless they are designed not to accept a high-capacity magazine? I have a picture, and I'll try to describe the weapon that I'm looking at here, a Browning Mark Bar 3, currently legal in Canada. But I give you that as an example as one of the models that could be. It's a semi-automatic, detachable magazine, 3 or 4 caliber, whether it's a 38 or a 303, but cannot accept a magazine of higher capacity. There's no possibility of adding a larger capacity magazine without modifying the weapon itself. In context, it seems that the manufacturer is also proposing high-capacity magazines for its models. If he were to create a different model for another jurisdiction, he would have to have a different design. particularly as to the magazine is concerned. This is what done with the detachable box magazine to allow for 10 cartridge charge. The definition proposed by the Commission on the mass killings in Nova Scotia would be classified with a different number if they had different magazine sizes. And it would be allowed if the original design contains no more than 5 cartridges to the magazine. The weapon could not be sold in Canada as there's no physical way of inhibiting the modification for a higher capacity magazine. Now, if we come back to those models that is sold in Canada with detachable magazine, 3 cartridges or 4, the alternate, there are alternative ways of arriving at a higher capacity magazine. And the proliferation of these high-capacity magazines would have to be stopped. It has to be, by design, to be impossible to put in a high-capacity magazine. The government's argument is that the appearance of this would retroactively reclassify these weapons. Now, eventually, there might be some factors outside of the control of a manufacturer, which is not the way that the gun is supposed to work, and that's not how our classification system is going to work. Back to the Commission's recommendation. If a gun or a firearm the size of the magazine depends on the intention of the manufacturer. In other words, he would have to be directed as to what is allowable and not allowable by capacity. Now, the question for manufacturers, in order to conform to the legislation, we have to make it explicitly clear. So I'd like a sub-amendment, Mr. Chairman. I'd like to propose a motion to 3G2. The clerk, I believe, has received copies of this sub-amendment, and I certainly hope that my colleagues will be able to support this sub-amendment, which would be an improvement to this bill, and reply to the concerns of survivors of various incidences in Canada. I could read it out if you wish, or I could wait until everyone has a copy.
Short, perhaps you could read it out. I think it's been distributed by the clerk. Right. Oh, there it goes.
To follow
Yeah.
along. Thank you, Chair.
So I think this would be an amendment to the motion that's before us, not sub-amendment.
Alors, l'amendement à la motion, Monsieur le Président, se lit comme tel, que la motion
Reads as follows, that G32, proposing the modification of Bill C-31 on line 15 of 1, be modified by the following substitution, initially designed with, and with follows. Originally designed with, in subparagraph 84.1c, sub 2, with the following, is designed to accept. Thank you.
Now, we are now on the amendment. So the debate shall continue on the motion as amended by Madame Michaud. And next on my speaking list is Mr. Julian, however.
I was just going to ask if we could suspend for 5 minutes to review the amendment, Chair.
It's okay? Suspend for 5 minutes. Save it for later. So we'll go now to Mr. Julian, I believe, is next on my list. Oh, sorry. Okay, yeah. Mr. Julian, please go ahead.
Merci beaucoup, Monsieur le Président, et merci pour...
Thank you very much, Chairman, and thank you for providing me a few minutes. I've taken a look at this, and it comes back to the language, the wording that we had last November, and I can't support that. In November, for example, there were many aspects which were quite ambiguous and unclear. Not too easy to understand exactly what the end purpose was. I think that the department has done a good amount of consultation. And while I can understand the sub-amendment, I don't see how it really makes a significant difference to the current amendment. So I'm going to vote against it.
The issue of time within this committee, we accomplished in 2.5 hours one amendment on Tuesday. Now, you know as well as I do in terms of the math, 145 amendments at 2.5 hours each, 390 hours. I've suggested before that we need more hours per week to really engage in this issue, particularly in light of the urgency around ghost guns and the fact that law enforcement is looking for these measures. And so it seems to me, if you talk about that number of hours, 390 hours, and only 4 hours a week, we're talking about 90 sitting weeks, which would mean, I'd suggested on Tuesday, that the pace we were going would mean that we wouldn't be completed clause by clause until October 2024. But given that we didn't complete the study at the end of, or that amendment at the end of the day on Tuesday, we're actually talking, surprisingly, Mr. Chair, about October 2026. It would take about 3.5 years at our current pace to go through clause by clause on this bill. And given the importance, protecting victims of domestic abuse, ensuring that ghost guns are actually tackled at a time we're seeing an exponential rise in the number of ghost guns anecdotally across the country, certainly in the United States, where they compile those statistics. We're seeing a marked increase in the number of ghost guns, which is why the Biden administration has cracked down. And over 20,000 ghost guns have been seized in the past year. This is an emergency, and I agree that the government made a mistake in tabling amendments back in the fall that were not clear and have led to this delay. But I think two wrongs don't make a right. We really need to proceed with this study and get the clause by clause completed so that law enforcement has the tools it needs to combat criminals who are using ghost guns, untraceable weapons. So I'm hoping I get the unanimous consent on this, Mr. Chair. What I would like to propose by unanimous consent, because that's the only way it can happen, so we request an additional 20 hours of hearings next week. That would mean 24 hours of committee hearings next week to go through clause by clause. I don't believe we can wait years before this bill is finally adopted. We need to move forward. And so I hope we'll get unanimous consent in order to do that, to request an additional 20 hours of committee time next week to add to the 4 hours that are already scheduled.
Thank you, Mr. Julian. So I think with a unanimous consent request of that kind, it's not debatable. Is that correct? And so we will go straight to a vote. Do we have? So we do not have a unanimous consent. Thank you, Mr. Julian. We'll carry on now with our list. We go to Mr. Calkin, please. Sorry, Mr. Julian, were you not finished?
No. I'm putting myself back on the list.
Okay, you bet.
No, I was on the list to speak to the main amendment, not the sub-amendment, so I'll ask to be put back on the main amendment speaking list for now.
Okay, Mr. Lloyd.
Thank you, Mr. Chair. And yes, the problem I have with Mr. Julian's unanimous consent motion is that
Point of order, is that not decided and we've moved on now?
Yeah, Mr. Julian's motion is defeated, so, or it's not a motion, strictly it was unanimous consent request.
So we're on the sub-amendment from Ms.
Correct,
Michaud,
we're
right?
debating a
Okay.
sub-amendment.
Thank you. I'm sure the chair will give me a little bit of latitude, but we can't judge past, past performances and say that's going to be the future. So the assertion that we're going to be here until October 2025 is ludicrous. It's not going to happen. So we'll continue on. Conservatives will not be in support of the sub-amendment as moved by Ms. Michaud. Thank you, Mr. Chair.
Thank you, Mr. Lloyd. Mr. Muff, please.
Thanks, Chair. The member who moved this is someone who I have the utmost respect for, and I know she does a lot of work, and I know she knows her subject well, and it pains me to say that we can't support her amendment. However, there was a lot of work done to come up with the wording that we have before us, and I have had the unfortunate position of amending on the fly at committee on previous bills, and it can have unintended consequences. And I do think that given the amount of work that went in and the consultation from the minister and his team to come up with wording that could be supported, not everyone is going to agree with it, and that's fine. But unfortunately, we're not able to support the sub-amendment.
Thank you, Mr. Moff. Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur le Président. J'apprécie les...
Thank you, Chair. I appreciate my colleagues' comments. I'd like to respond to Mr. Julian, who said my sub-amendment brings us back to a similar text last November. That is true, but at the same time, the November definition, semi-automatic or a hunting weapon, semi-automatic hunting weapon that was referred to in that case, center fire from a detachable high-capacity, whereby the weapon was originally designed. The proposal I'm making as a sub-amendment is that of the Commission on the mass killings in Nova Scotia. And I would recall that the minister said he was open to implementing some of these recommendations of that commission. So that's it for my comment, Mr. Chair. Thank you.
Julian again.
Thank you very much, Mr. Chair. I'm disappointed by Conservatives not allowing for the additional committee hearings that are needed around this, given how slow they have said that they are not engaged in a filibuster. They're honourable members. I know each of them, and I know that they may not perceive that they're doing a filibuster, but I think others would see it differently. And certainly looking now at coming up to 3.5 hours, 4 hours with just one amendment adopted, we can do the math at 145 amendments, and it's exponential. And the other element that's exponential, of course, is the plague, the epidemic of ghost
Point d'ordre,
guns
Monsieur le
on
Président.
the...
Point of order, Chair. Thank you, Chair. We're supposed to be debating my sub-amendment and not the one that Mr. Lloyd could not express an opinion, so Mr. Julian should be treated the same way.
I would suggest Mr. Julian take that into account, please.
Absolument, Monsieur le Président.
Certainly, Mr. Chair, and Ms. Michaud is correct on that point. However, I think it was important to say that this is really not working for the process here. Now, the sub-amendment. I've already said what I wanted to say on that issue. And of course, we'll come back to the question of the actual amendment once we've disposed with the sub-amendment.
So, Mr. Lloyd, you're up on my list next.
I guess my question to Christine, Ms. Michaud, this potential, like firearms are not designed to accept a firearm is not designed to accept a specific magazine of a specific size. Magazines come in all ranges and sizes. It's not the function of a firearm to determine what the size of the magazine is. It's the function of a magazine to determine what the size of a magazine is. And so I'm very concerned that this wording in an open-ended way could lead to the banning of a large number of semi-automatic hunting rifles and shotguns. Just wondering if Ms. Michaud has considered that this would potentially lead to the banning of a large number of hunting rifles and shotguns, and what her thoughts were on that. Thank you.
Mr. Lloyd is at the end of the list. If anyone wishes to speak again, go ahead. Go ahead, Madame Michaud.
Je remercie Monsieur Lloyd.
I thank Mr. Lloyd for his question, and I just to say that it is a prospective definition, and it may lead to the prohibition of hunting weapons, because it'll be applied to weapons that don't yet exist. And if the proposal made by the Commission on the Mass Killings in Nova Scotia, I think they did a colossal work, and they have very serious recommendations.
Thank you all. There being no further speakers, we'll vote on the sub-amendment. All in favor of the sub-amendment? All opposed? Désolé, Madame. The sub-amendment is defeated. We carry on with the debate on the main amendment. I think Mr. Cockin was on that list. I'm trying to maintain a little bit of, and then Mr. Julian.
Oh, well, thank you, Chair. And I guess now that we've got the sub-amendment question resolved, I still do have some questions, and I'm hoping the committee and the witnesses will grant me some latitude, because I wasn't here for the previous discussion on this amendment. But what I see here, I have some questions. I have some concerns. I am a gun owner, and I have trust issues as a gun owner, frankly, with a process that provides a definition and yet still provides another way to circumvent the definition. And if I read this amendment correctly in the context of the current law, it simply adds this section after Section D in the Criminal Code in the definitions of a prohibited firearm, and the one clause that would be before it, Section D, says any firearm that is prescribed to be a prohibited firearm. So that's the other process. So notwithstanding all of the discussion that we're having about Clause E being added into the prohibited firearm definition in the Criminal Code under 84.1, there is still an ad hoc way to declare a firearm, whether it meets or doesn't meet the definition that we're debating today, as a prohibited firearm, as has always been the case. And I think that's what genuinely frustrates law-abiding firearms owners, is the stroke of a pen method that somebody somewhere can just arbitrarily use that other process. So I'm just putting on the record, as a gun owner, that I am genuinely frustrated that we're spending so much time discussing a definition for which there is a process to completely circumvent the definition. And that's why I don't have any trust that even if we do come to a general consensus on this definition, that this isn't the only way in which I can, as a purchaser, as an owner, that anybody who is a business owner, anybody who's a manufacturer, there is no way of knowing by reading the law, if this amendment is passed into it, whether or not a long gun will still be prohibited, restricted, or otherwise. So it is frustrating to me, but I have some questions. I have some questions because It deals with Remington Firearms. I'll just use them as an example. Remington is getting back into business. They've made the 742, 7400, and the 750. So for the people that are here today as witnesses, you know which firearm I'm referring to, right? It's generally known as the Remington semi-automatic hunting line of their rifles. We all agree on that, correct? Is that, do you guys know which gun I'm talking about? So, Ms. Paquette, you understand that gun? Okay, good. So, I mean, that gun has obviously been designed. It's been in use for decades. We would generally agree with that sentiment, right? So, the 742 was basically replaced in production by the 7400, which was then replaced by the 750. Generally speaking, would you agree with what I'm saying?
I believe that's accurate, yes.
Yeah, and you would also agree that Remington designed generally speaking, for all of those models, a 4-round magazine, a 10-round magazine, and a 20-round magazine. Now, only the 4-round magazine is lawful in Canada, according to our laws. Am I correct in how I'm interpreting that?
Yes, but I think the definition is just one element. So when they talk about the magazine capacity, it's one element to determine. Okay.
Yeah,
it's not.
I don't think I'm going to go where you think I'm going to go.
Okay.
So
okay, sorry.
So the magazine issue is a completely separate issue, in my opinion, and unfortunately, because we actually don't have clarity, the first thing that we should actually be getting clarity on before we're discussing any of these legislative changes should be the one that actually deals with magazines. But all we have right now is what we currently have in regulation plus what the minister has said they're going to do, which means that I'm now guessing as a parliamentarian what that magazine legislation or legislative change or regulatory change might look like. But Remington is now getting back into the business. They've made announcements that they're going to create a new line of firearms. I'm assuming that it'll be based, and hypothetically speaking, but I mean, they're not going to reinvent the wheel. If they create a Model 800, small design changes, it's not the 742, it's not the 7400, it's not the 750. Let's just give it a number. Let's say it's the 800. It's a semi-automatic rifle. They're going to manufacture a 4-round magazine, a 10-round magazine, and a 20-round magazine, and introduce it to the marketplace. Is your interpretation of this piece of legislation, if it came to pass as law, is a Remington 800, if that's what they decide to call it, designed and manufactured on or the day, if they come out to the marketplace with that, they get the patent after this becomes law, is that Remington 800 now, because it comes with a 4-shot magazine, a 10-shot magazine, a 20-shot magazine, because it'll probably be interoperable on the platforms, as almost all the 700 platform is that firearm, is your interpretation, and would your recommendation and advice to either an order in council or whatever the process be, would your advice be that Remington 800 is prohibited?
I don't think the witnesses can speak to their advice, but they can give you answers to your questions about their interpretation.
Depending on the modifications of the design, so that's number one. We would have to evaluate what kind of design changes are made. If it's a new model, it will be applied against the definition, but it depends on what modifications are made to the firearm. So I can't really answer it until you know what changes are made.
So now it's not about the firearm, it's about the firearm model. Do I understand your answer correctly?
Should have said design. My mistake.
Well, this is important. This is important for firearms owners to know. These are the questions and concerns that I have. So if that was the case, in theory, if a Remington 800 semi-automatic 30-odd 6 because of an interpretation of this clause and an interpretation of the designs, even though it's interoperable now. Its magazines and everything is interoperable with a Remington 750, a Remington 7400, and a Remington 742. Would that put in jeopardy the firearms that are currently owned legally and would hopefully still be legal in this country? Would it put those models in jeopardy? Because it's just a different. I have had numerous Chevy pickup trucks. They're all 2500s, they're all Duramaxes, and they're all different over time. This is just a different form of the same thing, is what I'm trying to get at. And if the new form of the same thing is prohibited, then I can reasonably presume that the old form of the same thing will be prohibited. Am I wrong?
Hi, I'm going to answer this question. So thank you for your question. And I just want to recap to make sure we're on the same page. Your example is a new firearm that is designed in the future and produced in the future, yes? That is capable of...
It might be. It might be the exact same firearm, just marketed differently with a different model number. It might be the exact same thing as the last one that came out.
Okay, well, I can speak to the law, and maybe Ms. Paquette can jump in if I'm making a mistake. But the way the definition is drafted is it's meant to capture any firearm that is capable of receiving a magazine that can hold more than the legal limit. So in this case, it would be 6 or more. Right? Okay. So that would include a firearm that can capture that can accept a magazine that has 2 or 4 or 10 or 20. So that would be captured. So according to 2. The third part of the definition is that all of this has to happen in the future. So it would be a new design and then manufactured in the future.
And would your interpretation of the Kel-Tec Sub 2000 Generation 2 be different than the Kel-Tec Sub 2000 Generation 1?
Okay, I don't have the technical expertise to answer that question. I would defer to the CFP for that.
Is there anybody here that's qualified to answer that question?
Maybe I'll take a shot. Can I just step back to the question? I think it's, so existing makes and models, so your 700s, they are not affected by this definition, right? They currently are in the market. They were previously designed. They were previously manufactured. They will continue to exist and not be touched by that definition. We're good on that front, right?
I believe that's the intent, sir. Yeah.
Yeah. Okay. So that's the now now we move to the 800 model, and you mentioned that it's built on the same chassis, everything,
the same function.
If there's not a material change in the design, so again, I'm going to be hypothetical here, but let's predicate it under the fact that based on how the manufacturer comes out and markets that new model, how it markets, so it basically, is it defining it in any way different? Are there improvements being made? Is it really just something that is substantive or not substantive? So I'm going to give examples. So the mechanical operation changes or is not changed. So are we moving from, I don't know, let's say a gas-operated to a recoil system? Okay, so there has to be some material change. This isn't impacted by a color. So your Duramax Dodge trucks that went from a red to green to yellow isn't necessarily the way we interpret the design right now. Like, I'm just interpreting this, right, as you're asking us to.
That wasn't my point.
I know, but the reality
is... It's a little
is,
more substantive than that.
Well, it has to be a material change.
Okay, so just so I'm clear, because if the Remington 800 that is currently being thought up, drafted, designed, gets its patent, and comes to the market 2 years after this becomes law, can accept a Remington 750 magazine, or any magazine that worked in a Remington 750, any magazine that worked in a Remington 7400 or any magazine that worked in a Remington 742, it would meet the test of number 2. Would you agree?
Sorry, repeat that and meet the test of?
Because Remington
Yes.
manufactures a 4, 10, and 20-shot magazine, even though the 4-shot magazine is the only one legal in Canada, my question to you is, if Remington produces a Model 800 semi-automatic that accepts all magazines from the 750, 7400, and 742 platform, with a 4, of which Remington has made, 4, 10, and 20-shot magazines, would test number 2 be met because the Remington 800 is a, however minor the modifications might be, is a new model of the Remington semi-automatic platform? And I know what you're saying is it has to be a substantive enough change, but that's a subjective decision that is made by somebody. We don't know who those folks necessarily are, but in theory, I'm reading clause 2 as a Remington 800 semi-automatic 30-06, for example, that can accept a 10-shot 30-06 magazine even though it's not legal in Canada, but for the purpose of the law meets the test.
Point of order, Chair. It's unfair to ask officials to determine a future determination of a firearm that they can't. Well, they're asking the officials have answered as best they can, and now they're being asked to determine the eligibility of something that is completely speculation. It's putting them in a very difficult position to be able to say one way or the other when there's nothing in front of them. They've been clear about that.
Thank you for the intervention. I do think Mr. Cocken is trying to delve into the particulars of the definition, and I recognize it's very difficult. I think we have a couple of different questions, if I may, incorporated in your questions. I think there's a consequence of a derivative design. And secondly, if that derivative design is capable of accepting multiple cartridges, what is the circumstance? Would that be a fair summary?
This is, yes, and I just want to be clear. And I know I'm not trying to put anybody here in an unfair, I'm not being hostile in any way, shape, or form. And thank you, Chair. Your language is very articulate. So I'm trying to take comfort in the fact that if the derivative, let's say the 800, because we have history with that particular firearms manufacturer, we've got the 742 and the changes to the 7400, and we've got the changes from the 7400 to the 750. I mean, those are Remington has not reinvented the wheel, let's be honest. So that's why I pursued that line of questioning as our hypothetical example, and I understand, but I have to predict what this law is going to do in the future. That's my job as a parliamentarian, is knowing how changing the law affects the future. So I have to ask hypothetical questions. I think they're as fair, and I'm being as fair and reasonable as possible. I actually believe that if Remington came out with an 800 model that had as minor changes to it as the 7050 did with the 7400, I believe that because Remington originally designed cartridge magazines with 10 and 20 rounds in it, that test 2 would be met. But it has to meet all 3, right? We already know that it meets test 1 because it discharges centerfire ammunition in a semiotic manner. We all agree that it meets test 1. I think it meets test 2. So the only hope for Remington then to get the Remington 800 on the marketplace in Canada would be that it doesn't meet test 3. And if it's designed and manufactured, that model, and I think we've had this discussion about the model, if that model is designed and manufactured on or after a day in which the paragraph comes into force, and the example I gave you was that model is designed and comes onto the marketplace after this comes into force, is that Remington 800, in my opinion, you're going to have a hunting rifle that is now prohibited in Canada. Am I missing something? Or is there some way, I think Mr. Rob, I think it's Mr. Daly, I know that, I'm having fun. Mr. Daly, is there some way, because it would be nonsensical to virtually have an identical firearm, a Remington 800, branded prohibited or labeled prohibited, and a Model 750, which is virtually identical, be legal in Canada, are we going to have that scenario potentially? Or how would the law be interpreted so that something that seemingly asinine wouldn't happen?
Well, I think hanging on your words of virtually identical is a bit of a challenge, because then I would say if I take that for face value, there's not a new design here. So it doesn't meet test 3. That's how I get, and I think that's the best I can do in a hypothetical situation, right? Again, it comes back to the determination of whether or not this is actually a new design post this coming into force.
See the word new anywhere in the amendment in regards to a design. Am I missing something?
Yeah, what we did have the issue in test 3 was the original design, right? So I'm referring to then the opposite of.
Well, that's what I need. I need to know how the interpretation and how the implementation of the interpretation is going to work.
So if this model that you're speaking of, the 800, right?
Okay.
If it is virtually identical, right, then we would be using the original design specs. The
Okay.
original.
What would you say, based on your experience and knowledge of how the program has been administered over the years, how significant would the design have to change in order to be considered then a new design? Is there some examples that you can, because I brought up the Kel-Tec Generation 1 and the Kel-Tec Generation 2, virtually the same firearm, other than, actually I think the stock is all that really, or the way the stock works is all that really changed. Can you give me an example of would it have to be going from a gas operated to, I don't see that to be a significant change, but maybe you do, I don't know.
It could be that. I mean, I think it would have to be taken in a number of different criteria, right? So I gave some examples of the mechanical operation. It could be other things. It could be the size, the change in the frame size as well, the receiver frame size. That could have an impact as well. That would precipitate potentially us looking at it as a new design. Again, it's difficult to run hypotheticals through at this level, but again, I think we've given some examples of what would precipitate us to look at this as a new design. It would also be how the manufacturer is pushing out the material in their literature, right? Also how they're describing this firearm. So I think it's a combination of several features and factors that will go into making that determination. I can't just give you one specific feature and say, as long as they meet that, then they're in or they're out.
And it would normally be either the manufacturer or an importer that would send you a firearms reference table, or be applying for a firearms reference table ruling on the classification. Is that not how that works?
Yeah, or a designer, yeah.
Yeah, okay.
Yeah, and we would follow up.
Thank you, Chair.
Thank you, Mr. Calkin. We go now to Mr. Julian. Go ahead, please.
Thanks, Mr. Chair. I mean, we're now coming up to 4 hours on this amendment, and I flag two things. I mean, I've already mentioned the incredible length of time it would take to get through clause by clause on this schedule. I note that I proposed a pathway that the Conservatives have rejected, which was to request additional committee time next week.
Mr. Lloyd, on a point of order.
This isn't on the subject of the amendments. This is on the subject of his unanimous consent motion, and I think he should get back to the topic at hand. Thank you.
Thank you for your intervention. I think it is certainly pertinent to committee business. I think he's moving along into the amendment itself.
Well, it is absolutely appropriate, Mr. Chair, to speak of the time that has been spent on this amendment. Absolutely appropriate, as the member knows. The amendment itself is 7 sentences. It was received days ago. I'll recall getting 500-page omnibus legislation during the Harper government years that we were debating 24 hours later. And now we're days later, and a 7-sentence amendment is not being moved through at a time when we have 145 other amendments waiting after that. So it is pretty clear to me that what we are experiencing is a full-on filibuster. And given the size and scope of the important issue around ghost guns and what law enforcement are calling for, I think that's a real problem. And I think we'll have to find other solutions to this filibuster. On the amendment itself, it is very clear. I thank the officials. They've been very clear in terms of answering the questions. To my mind, in some cases, we're talking about questions that have been repeated or that are rhetorical. And hypothetically, when we know that we have legislation and regulation follows and then things are implemented, to go to the point where we're asking questions that are more properly in the latter stages after the passing of the legislation, I don't feel that's the right way to go. So I flag the incredible amount of time that has taken this week at a time when the committee should be moving forward. And I think if the Conservatives are not willing to schedule additional committee meetings, I think we have to find other solutions to this. I'll be voting in favor of this amendment.
Thank you, Mr. Julian. On y va maintenant, Madame Michaud. Allez-y, s'il vous plaît.
Thank you, Chair. I'm a little disappointed that my sub-amendment was refused, but I must say that the definition that we have before us is acceptable for this reason, that I will probably bend towards accepting it. I think the members have got answers to their questions, and we're almost ready to go to a vote on this particular amendment. It's been a long time we've been waiting for this legislation, and of course we hope that it can move forward more smoothly after this one. Thank you. Mr. Lloyd.
Followed by Ms. DeMoff. Mr. Lloyd.
Well, thank you, Mr. Chair, and perhaps Ms. DeMoff's intervention might not be necessary, but we'll see. The Conservative position is that this definition remains flawed for many reasons, including the reasons just eloquently brought up by my colleague, Mr. Calkins. There's some uncertainty in this definition. And the definition also does leave it open that hunting rifles and shotguns will be banned on a go-forward basis. Also, this government has seemingly left the door open through a proposed advisory council and a mandated parliamentary review on a definition. And so we don't know what those will recommend, but it's certainly leaving the door open for a future revised definition that would go forward and ban hunting rifles and shotguns. And we should remember what the Prime Minister did say not too long ago, that, quote, there will be some guns that we have to take away that will be used that are used for hunting purposes, end quote. So Conservatives will continue to hold this Liberal government to account. We will continue to stand up for law-abiding hunters and sport shooters so that their hunting rifles and shotguns will not be taken away. And in order to assuage the concerns that Mr. Julian has brought up on numerous occasions, I will say that Conservatives are ready to vote on this matter. Thank you.
Thank you, Mr. Lloyd. Ms. DeMoff.
Thank you, Chair. I just want to get on the record and clarify this amendment in front of us will not ban hunting rifles. And to speculate on future firearms that may or may not be banned and give the impression that we're trying to ban hunting rifles, these are firearms that don't exist. So, you know, there tends to be clips that get out there, often including me, that then give the impression that we're doing something that we're not. So we are not banning hunting rifles, so I want to be very clear on that. And I do want to thank colleagues for the work that we've put into this, and I'm pleased to hear that we're going to get to a vote, so I will end it there. I would like a recorded vote, though, Chair.
Very well. Mr. Clerk, would you carry out the vote, please?
Ms. Damoff?
Yes.
Mr. Cheng?
Yes.
Mr. Gahir?
Yes.
Mr. Morrissey? Mr. Shifke?
Oui.
Oui? Yes. 1 second. My apologies. Mr. Ruff,
Against.
Mr. Lloyd,
No.
Mr. Shields,
No.
Mr. Calkins,
No.
Madame Michaud,
En faveur.
Mr. Julian.
En faveur. In favor.
7 in favor, 4 against.
Thank you all. So the motion carries. I know we all have the bruises. Thank you all for getting us there. Wouldn't that be nice? Okay, in that vein, we have until 6, but I think if we go to 5:45, it will be the full 2 hours that we were allocated. Is that okay to everyone? Yep, okay. So carrying on, next on our list is NDP motion, NDP 0.1. And I will note that if this motion is adopted, BQ2 and CPC2 cannot be moved because they affect the same line. Mr. Julian, if you please.
Thank you very much, Mr. Chair. I'll be brief. I will flag that the original NDP member of this committee, Alistair McGregor, has proposed this amendment, and it is his birthday today. So I hope that is additional incentive for members of the committee. I'm sure he would be pleased, as would the airsoft community. I mean, we're talking about very serious issues here. We have a framework in terms of the bill. I've mentioned previously the issues around airsoft, the issues around the manufacturers' loopholes that would be tightened up with the amendment that we've just adopted. These are important and serious issues. What has been flagged by airsoft, the airsoft community, and these are folks that enjoy airsoft the recreational way, and is the concerns around the bill treating them in what is really not an appropriate way. The intent of the amendment would be to take Clause 1 out, and basically that still allows members of the government to look at a possible regulatory approach. We understand that the government does have the ability to set regulations. Members of the airsoft community have been very open, as you know, Mr. Chair, in coming before this committee, and in talking with members of this committee to say that they're open to regulations around airsoft. But the reality is the current Clause 1 would have a serious impact on airsoft practitioners, as well as a number of businesses across the country. And so on behalf of Alistair McGregor, who's been a strong champion of those who are airsoft practitioners, I'd like to move the amendment, and hopefully it will receive support from all members of this committee.
Thank you, Mr. Julian. Is there any discussion on this amendment? Ms. Demoff, go ahead.
Thank you, Chair, and I do want to thank Mr. Julian on behalf of Mr. McGregor, because I do know he did a lot of work on this. I would like to give a shout out to the airsoft industry, who were incredibly willing to work with us to regulate the industry. I do have concerns about gas-powered airsoft rifles. It was something that we saw at the gun vault, and I do have concerns about those, the ability of those to be converted. While we won't be able to support the amendment, we won't stand in your way, because my understanding is the government can provide regulations. And as you had mentioned, Mr. Julian, the industry came here and told us that we're fine if you regulate age. We're fine if you look at regulating transportation and storage. We don't want these airsoft to get into the hands of kids and to be taken to a school and having a child killed because they're carrying their parents' airsoft rifle. So I do want to thank the industry sincerely, because they were incredibly good to work with and were very concise and came with solutions. And I thank you for bringing this forward, Mr. Julian.
Madame Michaud, allez-y.
Merci, Monsieur le Président. Je remercie
Thank you, Chair. I thank Mr. Julian for his comments and Mr. McGregor, for whom we worked with whom we worked with during the other committee. And as Ms. Demoff has just said, we can see to what point, according to the RCMP, to convert an airsoft type weapon into a true weapon that can actually be adapted quite easily. And I think it's quite extreme to ban airsoft weapons in C21. They came before us, they were quite open to be regulated and come under regulation. And Mr. Brian the representative of Airsoft Canada, when he appeared before us, said that the best way to reduce risks would be to ban the sale of these compressed air or gas-fired weapons to persons under 18 years of age, and of course to educate parents as to the important risks, perhaps even resulting in fatality in the use of these, even if they're using BBs. They're prepared to go further, and self-regulatory regime like the one in the UK, which is analog organization, should be used only in a range that's devoted to BB using weapons. The measures proposed also correspond to the Airsoft Quebec Association, the same with Airsoft BC and the Association of Munitions, the FAA. We would propose to the government to encourage Governor and Council to cooperate and consult more closely with these associations for compressed air weapons, and convince with them to find a solution to this issue. I have a question for the officials that are here today. Can they confirm that there does exist a possibility today for the government to regulate airsoft weapons without them being mentioned specifically in Bill C-21? Is there not another way out, if you will, to regulate airsoft weapons, but not by including them in his bill? Well, we'd have to do a more fulsome analysis as to the policy repercussions of that particular proposal. I suppose it is doable. Anything is possible with the correct political will. Thank you. Given that it would be possible to do so, I would like to propose a sub-amendment which would allow the government to regulate these category. As you say, anything is possible. I would vote in favor of Mr. Julian's motion. I was going to present the same amendment that would remove any mention of airsoft in this particular bill, I should say.
No, okay.
Non, Monsieur le Président.
No, I don't need to at this point. Thank you, Chair.
Mr. Lloyd, if you please.
Thank you. This is going to be a question to officials. So I do note that the legislation that is seeking to amend does draw a distinction between replica firearms and antique firearms. So it does not apply to antique firearms as far as I understand. In antique firearms, the definition is a firearm that was produced before 1898. That seems to be the date. Now, we received witness testimony, a brief from the Toronto Artillery Foundation. And the Toronto Artillery Foundation operates a number of old, but these are World War II era, so that'd be post-1898, 25-pounder cannons, which are used for, ceremonial, public purposes. These have, I think, tremendous value for ceremonies. We have the 21-gun salute here on Parliament Hill, as a tourist attraction. And so I just want to get some explanation from the witnesses here. Does this impact these 25-pounder? Would they be classified as firearms? They wouldn't be given an exemption under antique. What is the state of these cannons in the legislation, in this amendment?
There's nothing in the amendment that changes the current law around antique firearms.
But it's not an antique firearm.
Sorry. So your question is?
Because it's a World War II era, so that's 1939 to 1945, so it's not covered under antique firearm. It's not technically maybe it's a replica firearm, but these are real cannons, I believe. And I believe under the joules and the bore diameter, could these firearms be banned under an amendment like this?
So as the proposed amendment, if these were actually regulated firearms, so if they had a velocity over 152.4 meters per second and had a muzzle velocity in excess of 5.7, and so if that's what they had, then they would be firearms, regulated firearms, and if you had a replica of a regulated firearm, then they would be prohibited. So the example that you gave would have to exactly resemble what your example is. It would have to exactly resemble a regulated firearm.
In order to be exempt?
In order to be captured. So if your example does not meet the definition of a regulated firearm, then it would not be a replica.
Understood. Thank you.
So that's the threshold now.
Thank you.
That would be the threshold.
Seeing no more speakers, shall we vote on this amendment? All in favor of the amendment? Opposed? Carried. Thank you very much. That being the case,
Point of order, Mr. Chair.
Yes, go ahead.
I will be wishing Mr. McGregor a happy birthday on behalf of this committee.
I actually meant to say that before I got carried away with saying the motion was carried. I'm so excited with all the motions we've been passing in the last few minutes. But I do also join with you in wishing Mr. McGregor, and I expect the whole committee would like to wish Mr. McGregor a happy birthday. One more successful trip around the sun is always a good news, right? Thank you all. Okay, so BQ2 cannot be moved because it affects the same lines. CPC2 cannot be moved, and that brings us to G5 in the name, I'm sorry? Oh, yes, of course. A very important part that I missed. Shall Clause 1 carry? All in favor? Opposed? Carried. Okay. So now, yeah, can't do that. Okay, now we go to G5. Which is standing in the name of Mr. Nur Mohammed and Ms. DeMoff.
Thanks. Because my colleague, Mr. Nur Mohammed, is not here right now, I'm going to do what Mr. Julian just did and move it on his behalf, because I know it's an issue that both he and Mr. Shifke care a great deal about. We've already passed one amendment to do with ghost guns or 3D printed firearms, or as the police call them, I think it's privately manufactured firearms. We have a whole bunch of these, so I'm just so you know, Chair, I'll move them in Mr. Nur Mohammed's absence unless Mr. Shifke wants to move one. But this is incredibly important for law enforcement. I hope everyone can agree. What these amendments are doing is adding the words firearm parts to different sections of legislations to ensure that these privately manufactured 3D printed guns are not able to be used in the commission of crime.
Thank you, Mr. Moff. Is there anyone wish to speak to this amendment? Seeing none, let's have a vote. All in favor? Opposed? Carried. Thank you all. We go now to G6. Also standing in the name of Mr. Nur Mohammed.
My colleague, Mr. Shipke, wanted to move this one.
No, I think
No? Okay.
It's okay, Mr. Moff, you can move it.
Okay. Similar to G5, this is another addition of the words firearm parts. So I won't talk about it a lot. I just did, so I hope that all of us can vote in favor of this one.
Mr. Lloyd, go ahead.
Yes, well, Conservatives do support expanding the maximum sentence for those that commit crimes in relation to the trafficking of weapons and firearms. We are deeply concerned about the watering down of some mandatory minimums, and we do note that nobody has ever actually received a maximum sentence. So it is our hope that that we do see stronger penalties for those who commit these acts, which are causing violence in our communities, which is unacceptable. Thank you.
Thank you, Mr. Lloyd. Any other speak? Mr. Moff, please.
Just to quickly comment on that, legislation doesn't, judges make the determination on the sentence, not elected officials. This does increase I was incorrect about this does increase the sentence to 14 years from 10 years as it currently is, associated with weapons trafficking. So my own personal cheat sheet was actually wrong in what I had written about it being ghost guns. This is actually increasing the penalty to 14 years from 10 years.
Thank you, Mr. Moff. Any further discussion? Seeing none, let us conduct a vote. All in favor of this amendment, please raise your hands. Opposed? Seeing none, carried. Thank you all. This brings us to G7, also in the name of Mr. Nur Mohammed. Mr. Moff, I believe, go ahead.
I'm sorry, Chair, we just did G6, right?
Yes.
Okay. And G7, similar to the previous amendment, amends the criminal code offense of transfer without authority to include the transferring of a firearm part, which is all tied to ghost guns.
Any discussion? Mr. Ruff, please.
Just for the officials, so it's clear, I mean, we sort of discussed this briefly on Tuesday, and I know it's future, I think, amendments, but as long as you have, this isn't going to require to have an ATT to actually move the part. As long as you have your PAL or our PAL, depending on the firearm, you're good to go, correct?
That's correct.
Thank you.
Discussion? Seeing none? All in favor? Opposed? Carried. That brings us to G8. That also stands in the name of Mr. Nur Mohammed. Mr. Moff, please go ahead.
Thanks, Chair. I think all of us who visited the RCMP gun vault were shocked at how fast and easy it is to 3D print a gun or a receiver, and also how readily available this is. So this clause sets about deals with computer data and the computer system used in new offenses. So this is new. It is extremely important for addressing the rise in ghost guns. Back in the day, you needed a gunsmith to be able to create these receivers, and it was literally within minutes, while we were standing in the room, that the 3D printing was able to happen. So if colleagues have questions for officials to clarify this, but these amendments will deal with adding offenses to deal with the 3D printing. It will also make Canada a leader in the world when it comes to addressing ghost guns. I met with, I mentioned this at our last meeting, but when I met with Inspector Michael Rowe in Vancouver, he said that these weapons are they are the preferred weapon for hitmen. They are becoming the preferred weapon of gangs, and it gives us an opportunity as legislators to actually get ahead of organized crime instead of playing catch up, and give police the tools that they need to be able to prosecute those that are manufacturing these firearms, sometimes in a home in a residential neighborhood. So I'm hoping that colleagues will support this amendment.
Thank you, Mr. Moff. Mr. Lloyd, please go ahead.
I do have some reservations and questions about this. I'll ask officials. Is it clear, in a court of law, if you're in possession of something, just being in possession of schematics for the construction of a ghost gun, there's nothing criminal about that. So the government has to prove that the possession of these schematics is for the purpose of weapons trafficking. Is that correct?
That's absolutely correct, yes.
Yeah, because I've had a number of civil liberties people and lawyers come to me and say they're very concerned because, for example, if somebody had a manual for how to construct a conventional firearm that was even a legal firearm, like a legal design to be legal in Canada, that's not what's being dealt with here, but you'd have to prove that they're planning to distribute that schematic for the purpose of committing a crime.
Correct. There are two elements to any criminal offense, the mens rea and the actus rea.
Okay.
And the mens rea in this case would be for the purpose of manufacturing. So just having simple possession of a schematic, a drawing, et cetera, on your computer would not be captured by this, or the intent is not to capture it by this offense. You would have to have that additional mens rea or the intent for the purpose of trafficking for the first offense. And the second offense, which would be the distribution of blueprints, you would have to have a mens rea of knowing that blueprint or design or schematic would be used for the purpose of firearms trafficking. And it would have to be a firearm derived from the data.
Is there any precedence in our law for something like this, that a design for something, that possession of a design for something, even if it is for a criminal, proven that it's for a criminal purpose, is a crime?
So in my review, I recall looking, the closest offense I think that we came up with was the possession of, possession of child pornography. So accidentally accessing it, accidentally looking at it or viewing it would, you need the requisite mens rea. And possession is defined in the criminal code in section 4. So it really lays out what possession would be in those cases. And the courts, of course, would have.
Thank you for that clarification.
Thank you. We go now to Mr. Julian, followed by Mr. Ruff. Mr. Julian, please go ahead.
Thank you, Mr. Chair. I'll be supporting this amendment. Having had the opportunity to meet with the RCMP in Surrey, British Columbia, it was, I think, an eye-opener to see the extent to which a 3D printer with the possibility of certain software, plus legally obtained firearms components, obtained without a PAL, possession of ammunition, all of these things added together and law enforcement officials indicated how difficult it was currently with the current law to do the appropriate follow-up. And as I've mentioned many times, I know law enforcement has mentioned this as well, the increase of ghost guns in the streets across this country in certain regions like mine has increased exponentially over the course of the last year or two. This isn't an issue that is slowly developing. This is an issue that is exploding. 20,000 seized ghost guns in the United States, and the Biden administration taking action. Canada needs to take similar action and equip law enforcement with the ability to crack down on criminals. And I think essentially Bill C-21 is becoming more of a bill that is cracking down on criminal behavior. These ghost gun provisions are vitally important to that. We have to crack down on criminals, cut off their source, and make sure that they do not have untraceable firearms. That's a danger to the public. There is no doubt. It's a danger to all of us. And so I'll be supporting this amendment.
Thank you, Mr. Julian. Go to Mr. Calkin, please. Oh, I'm sorry.
I thought it was Mr. Ruff.
I lost track. Mr. Ruff, followed by Mr. Calkin.
Thanks, Chair. Look, my question is very simple. I mean, look, I have no issues with the intent behind this amendment at all, and I appreciate the clarification from the officials to Mr. Lloyd's questions around the intent and everything. Has there been a charter statement done specific to this amendment? Because it obviously gets into some very gray, vague areas with all this lawyer stuff that I don't profess to be an expert on.
So no charter statement was done specifically on this offense. The charter statement was tabled back in June of 2021, but we do an analysis of all of the government motions. Again, taking into consideration charter impacts, such as on free speech, in terms of distribution of these types of blueprints. So any charter analysis that would have been done is solicitor-client privilege, but we can say that it wouldn't criminalize merely distributing or publishing, and it would not impact on free speech because you have to have, the person has to have possession with an intent. So
But you are clarifying the charter statement was done on the original bill. This new amendment, it wasn't, but there was analysis done, fully acknowledging you can't share it, but you did, a charter analysis was done on this amendment.
Analysis that we do on motions, as I mentioned yesterday, gender-based analysis, et cetera. Yes, we do charter analysis on these provisions. And, sorry, go ahead. Oh, on these, we always, yes, on every initiative during our policy development.
Thank you.
Mr. Calkin, followed by Mr. Shields.
Thank you, Chair. I actually, like my colleague, Mr. Ruff, I actually think this is the kind of stuff that we should be focusing on rather than going after law-abiding firearms owners, but that's just me. But I do have just a couple of questions about this amendment. And from So my last job before I came here was I was a tenured faculty member teaching computer systems technology at a local college. So IT is something that I know, I've forgotten more than I probably ever should have known in the first place. That was 17 years ago, and the technology has changed immensely. But I don't see the word knowingly in 1021 or with intent in subsection 2. I actually don't know what, I'm a former computer programmer, a systems analyst, a database administrator. I don't know what every file is on my computer. I suggest that each of you that are sitting down here as witnesses don't know every file that's on your computer. Shouldn't we have some language that says that you must knowingly have this on your, because it would be very easy for anybody with any technical skill whatsoever, and that's not me anymore. It would be very easy for somebody to push a file to a computer, push a bot, push anything like that onto a device, and then all of a sudden you're circulating information or your machine is circulating information that you have no idea that you're circulating. It happens when it comes to pornography. It can happen when it comes to technical plans for firearms. It's so, I just didn't see the language, so can somebody reassure me that knowingly and with intent is part of this amendment?
So I can appreciate the concern, absolutely, around that kind of, what that type of concern around accessing these types of schematics. For the sub 1 offense, which is the possession offense, it is that the person did it for the purpose of manufacturing. That is a well-known standard, that part, right. So the second, sub 2, which is the distribution offense, has language in it that says knowing that the computer data are intended to be used for the purpose of. So the element, the mens rea element is set out in that subclause, and it is on 2, 3, 4, 5, 6, 7, 8, the 8th line.
Okay, so the mens rea is there, the actus rea.
Yes. The actus rea is actually doing that, yes, that activity. So a prosecutor would definitely have to prove that someone did do the sharing, making available, distributing the schematic for the purpose of, yes. So those two elements would have to be proven. I understand the concerns, and I...
Yep. Okay, thank you.
Mr. Shields, if you please.
Chair, and it's probably along a similar, and I think it's very important as we're moving this, and I think we're actually behind, not ahead myself. I saw high school kids making these things 20 years ago. What they could do with 3D printers was incredible then. So, I mean, I think we're behind. But I think this is going to get challenged in court, and I don't think it's tight. I think it's an attempt, but I think we'll lose because the bar is so high that I think you will get out of this one. But it's an attempt, and I agree with the attempt. But I think the charter writes lawyers, and it probably will have to be dealt with again at some of the way, but the bar's too high, and I don't think it'll work. Thanks.
Thank you, Mr. Shields. Mr. Julian.
I'd like to ask the officials then. I mean, the department does a vetting, including under possible judicial challenges. Does this hold up?
So obviously, advice that we give to our ministers is protected by solicitor-client privilege. But as my colleague has indicated, we do a robust charter analysis of all draft legislation, including motions. But I can't give you a definite I can't give you an answer to that without violating solicitor-client privilege.
But it is fair to say it has been fully vetted.
It has gone through the approval process.
Yes, yeah, and that includes having an analysis of what the impacts would be on the charter.
So whenever we draft legislation, we provide our ministers and decision makers with a full suite of analyses, both from a policy perspective and all relevant legal aspects.
That's important, I think, for committee to know. Thank you very much.
Thank you, Mr. Julian. Seeing no more speakers, let us carry out the vote. All in favor of this amendment? Opposed? Carried. This brings us to G9. Standing also in the name of Mr. Mohammed, who will be stood in good stead by Ms. DeMoff.
I know he's going to be very disappointed he didn't get to move this, and his colleagues will see I did my own little cheat sheet on how many were ghost gun amendments, and so these are all amendments that are adding the word firearm part. So G9 is the same thing. Already said what I needed to say. There are multiple of these, so hopefully we can go through them fairly quickly. This one is adding firearm part to importing and exporting. So I'll leave it there. This is all existing legislation that just adds firearm part to it.
Mr. Lloyd, go ahead.
I did read some of the transcript of the last meeting, but was there sort of clarification on, like, part means an essential part, correct? Like, if somebody was talking about like a wood stock on its own, does that count as a firearm part?
Thank you for the question. So I believe a motion on Tuesday was all barrels and handgun slides as well as prescribed parts. So it is limited to those pieces.
So like essential components, okay, thank you.
A receiver and may
Go
I
ahead.
add on to my colleagues? A receiver and a barrel are already determined as, or defined as firearms in Section 2 of the Criminal Code. The definition of firearm part in G 3.2 or 3.2. 3.1, sorry, adds these two additional barrels and slides. So those four parts would be prohibited if this passes and carries today. No, sorry, not prohibited. Sorry, would be firearm parts. Would be firearm parts. Sorry, I apologize to the committee.
Can you just repeat those real quick?
So, receiver, a frame and a receiver? Sorry, a frame and a receiver in Section 2 is considered a firearm. Those two parts. If it got, yes, frame or receiver. Sorry? Not a barrel. A barrel and slide would be, handgun slide would be under firearm part, defined under firearm part. Yes, as firearm parts.
Are we good? We're good? Okay. Seeing no more speakers, let us, at breakneck speed, have another vote. All in favor of this amendment, please raise your hands. Opposed? Carried. This brings us to G10. Also, in the name of Mr. Nur Mohammed. So please.
Thank you, Chair. Similar amendment, adding the words firearm part to give our police services and law enforcement the tools they need to combat ghost guns.
Any discussion? Seeing none, let us have a vote. All in favor, say yes, or raise your hands. All opposed? Carried. That brings us to the end of Clause 2. So, shall Clause 2 carry? All in favor? Shall Clause 2 carry? All in favor? Opposed? Carried. So that brings us to Clause 3, and I'm thinking that we have this excellent momentum. It might be a good place to stop. To carry the enthusiasm into the next meeting, which will be Tuesday. Is that to everyone's liking, that we draw a line here? Mr. Julian, please go ahead.
I would like to propose a final time for unanimous consent, a request for an additional 20 hours next week for this committee, given how slow our progress has been. I'll propose that again. It has to be adopted at unanimous consent.
Do we have unanimous consent for? No, we don't. Sorry. In that case, never mind. We have made enormous progress today, and I thank you all. And I thank the officials for, as always, giving us such excellent advice. And with that, we are adjourned.